also providing that to you if that's helpful to anyone. If so, just pop into the chat with a comment. Otherwise, I know a lot of folks have that ability to record and pull from screens already, and you may be doing that on your end of things. Okay. All right. Well, thank you all for joining us today. My name is Sam Petto. I'm the Communications Director at the ACLU of Nebraska. That's SAMPETTO. I want to thank you all for being here, and special thanks also to our funders who helped make this possible. It's a Woods Charitable Fund and Omaha Community Foundation. And thanks for Kathy and Nicole joining us this morning. What we're here to do today is introduce and share the findings from our newest report. I will put a link in chat. Also, if you go to aclunebraska.org/broken rules, you're going to find a PDF version of this. And what it is a culmination of an intensive project that we announced in the summer of 2021. It's focused on so-called debtors' prisons, the idea that our freedom should never depend on how much money we have or have access to. So we're going to discuss next steps, how we build on this project, and also what we found watching 2,300 plus combined bail and sentencing hearings. I want to specify we were specifically looking at Douglas and Lancaster counties with this project and compliance with laws that are meant to protect Nebraskans who are financially struggling. The headline of all of it is that after years after reforms, we are still seeing court practices that still enable debtors' prisons. And those practices include the habitual use of cash bail, failures to assess ability to pay, and issues with court advisements related to ability to pay. Today, you're going to hear from Rose Godinez, Senior Legal and Policy Counsel, to discuss those key findings. You hear from Dr. Rich Weiner with the University of Nebraska-Lincoln, our analyst, explaining his process and why we can have confidence in our numbers. And you'll also hear from Mindy Rush Chipman, our legal director and interim executive director, talking about next steps, what we do with these numbers and how we move forward to focus on solutions. So it took a lot of significant work to discover these trends. I'm going to invite Rose to speak to how she and the team made it happen, and also what we discovered.
Thank you, Sam. Hello, good morning, everyone. My name is Rose Godinez, spelled Rosegodinez, and pronouns she, her. I am Senior Legal and Policy Counsel at the Nebraska affiliate, the ACLU of Nebraska. Sorry, I'm used to introducing myself to other ACLUs. Before I get into the three key findings of our court watching project, I want to provide you all some context. As you all know, a major focus of the ACLU's work is addressing the harms of mass incarceration. And every day in Nebraska courtrooms, in fact, as we sit here right now, there are dozens, if not hundreds, of Nebraskans across the state, moms, dads, daughters, sons, brothers, and sisters, standing before a judge about to be imprisoned because they lack the ability to pay bail or fines and fees. And right now, that may mean some Nebraskans are held pretrial, presumed innocent, are spending the holiday season behind bars, while other Nebraskans are able to go home and celebrate the holidays with their loved ones. The difference? Money, resources, and knowledge of their rights. Too many Nebraskans with limited resources and Nebraskans of color are caught in this maze of rules and statutes and regulations with dead ends at every turn. Because stakeholders, and when I say stakeholders, I mean judges, prosecutors, and public defenders, are failing to implement or advise defendants of their rights and options as required by the law. The ACLU of Nebraska, knowing this issue, hired 24 court watching clerks, specifically for this project, both law students and students that are studying social sciences or have an interest in the legal field. We had 2 lead court watching supervisors. One of them is here with us today, Demetrius Gatson, and another, Riley Wilson. And I just want to take that time to thank them for their leadership and role in this project. It wouldn't have been possible without them. The court watching team observed in total 639 bail hearings and 1,700 sentencing hearings in 20 judges' courtrooms, all occurring between January 2021 to April 2022. Then the court watching team organized that information in digital spreadsheets and provided them to Dr. Rich Weiner of the UNL Legal Decision Making Lab. And they analyzed the raw and anonymized data for themes and significant relationships that I will go into in a little bit. And Dr. Reiner will also come right after me and talk about that analysis. So now to turn to the findings. First, we saw judges assign cash bail more than any other option. Of 501 cases where judges did not find the person to be a danger to the community or a flight risk, only 90 of those people, 18%, were released on their own recognizance. This is problematic because it errs toward incarceration rather than freedom. And since 2017, state law is clear that the courts should, and I quote, consider all methods of bond and conditions of release to avoid pretrial incarceration. Except for very limited exceptions, the presumption should always be in favor of releasing people on the least restrictive conditions, if not personal recognizance. The second finding we go into in our report is we saw judges often did not ask about financial ability to pay when imposing cash bail. Since 2017, again, state law has required judges to consider ability to pay and to impose the least burdensome condition that will reasonably assure that the defendant will appear to the hearing and minimize any risk to the community at large. In 39% of observed cases, judges did not ask about ability to pay. And in most of those cases, the public defender themselves did not bring it up. Third, judges frequently did not advise Nebraskans of their rights in regard to fines and fees. Across 1,700 observed sentencing hearings, judges advised Nebraskans of their ability to present information on ability to pay in just 59% of cases. And advisements on those options, when I talk about options, I'm talking about discharge of a fine, community service, or a payment plan, all provided for in statute, were even less common. In fact, judges shared information on the right to request waived fines and fees in just 4% of those hearings. Also of concern, many of these advisements were given at the top of the docket hour. So the judge would give an advisement generally at a certain hour and then not give it to each individual. So if you came in late, you wouldn't have the advisement, you wouldn't know your rights. So with that, I will turn it over to Dr. Rich Weiner to discuss the analysis of this data.
Oh, Rich, you're muted.
Is that better?
Yeah, that's excellent.
Excuse me, you'd think by now I'd know how to do this, but I keep making that mistake. My name is Dr. Richard Weiner, R-I-C-H-A-R-D-W-I-E-N-E-R. I have a PhD in psychology and a master in legal studies. I'm a professor and faculty member at the University of Nebraska-Lincoln in the law and psychology program. And my role in this project is I am the data analyst for analyzing the data that the ACLU presented. The data is in fact owned by the ACLU. They retain the right to disseminate it. The role of UNL in this project and the UNL team was to analyze the data and present the findings to ACLU and guide them in writing a report. The way this process worked is that the ACLU sent the de-identified data to UNL on a secured server, that is data without names, or identifying information for defendants, or identifying information for attorneys, judges, or cases. We had bail hearing observations from Lancaster and Douglas County in this data set, and we also had sentencing hearing observations from Lancaster County and Douglas County in the data set. So that's an orientation to what the data looked like as I received it, and our team began to analyze it. Next, I'm going to talk about the data analysis steps so that you understand how it was that we were able to come to the conclusions that Rose just talked about. The first step is that we got the data in an Excel file and turned it into a statistical package. We used SPSS for the statistical analysis. The second step is in fact cleaning and organizing the data. That's common to any data analysis project. That means correcting any errors that we found in data collection, things like data in the wrong columns, misplaced numbers, some missing data, and that sort of thing. That's common for all observational data analyses. And in fact, for this data set, overall, there was a very low error rate. It did require some recategorization and some clarifications, But when we finished that, we had the data in a form that we can analyze. We analyzed, or actually organized, the observations of each of the court hearings by case, case within judge, and judge within county. And then we separated the bail and combined the observations into a single data file without the observations collected, as Rose said, from January 31st, 2022 through April 28th, 2022. That consisted of 356 bail hearings from 5 judges in Lancaster County and 283 bail hearings from 15 judges in Douglas County. The first thing to note was there was a great deal of variability on the number of hearings per judge, anywhere from ranging from 3 to 161 hearings. So that we were able to analyze the data across the judges through the different counties. The first step in analyzing data of this kind is to conduct some descriptive statistical analyses. We did that, and we offered them, presented them in tables and charts that included percentages for things like whether the defendant was in custody, the type of charge, whether it was a violent charge, trespassing charge, domestic violence, property offense, and so on. We also classified and descriptively presented information on the defendant attorney, whether it was private versus appointed versus not appointed. We looked at and categorized the percent of people that were released upon their own personal recognizance and those that were not. We also described the percent of clients that were indigent or had no funding, no funds. And we looked at the bail amount ordered, which showed quite a bit of a range, but which did show a median of $5,000 at each in particular case. So all this data that I just described in these descriptive statistics are summarized, and they're in the appendix to the ACLU report, Broken Rules, that Sam presented earlier this morning, and also that you have the link for that you could look it up and obtain a PDF report based upon the analysis that we did. I want to end and conclude by telling you a little bit about some of the prediction analyses that we did. After doing the descriptive statistics, we conducted some inferential statistic analyses separately for the 2 counties, looking at the outcome factor of released on own recognizance. This was a multi-level modeling, if that means something to anybody who's a statistical nerd in the audience, that in which case cases were nested within judges, judges within courts. So we had both case level factors and we had judge and county characteristics in the data analysis. This type of analysis allows us to estimate how much variability was due to differences in the different judges' decision strategies. Our results showed that 44%, a significant amount of the variability in denial rates across cases, was attributable to differences in the judges' responses themselves. We conducted some outcome analyses looking at that ROR, recognizance factor, and we found no significant effects in the ROR for whether the judge found the defendant dangerous or likely to abscond, which is a finding that Rose spoke about earlier. There were significant effects, however, for the prosecutor. When the prosecutor opposed releasing the defendant, they were many times more likely to be denied release on their own recognizance. And so we presented all those results, both the descriptive statistics and the inferential statistics, and filed that report with the ACLU. And they put it, in fact, based their report on our analyses, and that is part of the report that Sam referred to. We reviewed the report as it was being written and the press release that was sent out today to make sure that the statements and conclusions were true to the data analysis. And as far as we can tell, the report does a good job of summarizing what we found and how we did those data analysis.
Thank you. Thank you, Rich. And next up is Mindy talking about what we're going to do with this information and how we're going to be working to affect change.
Thanks so much, Sam. So again, my name is Mindy Rush-Chipman, and I'm the legal director and interim executive director at the ACLU of Nebraska. My name is spelled MindyRushchipman, and I use she, her pronouns. Today, as you've heard, with the publishing of this report, we're ending the first phase of our court accountability work and moving to the next phase. We're shifting our focus from investigating the breadth and depth of the problems that we've heard Rose and Rich speak of, and we're moving to implement solutions. As early as today, I've been in contact with leaders in our judicial branch, and we will be sharing this report with them this afternoon and asking for their support in adopting solutions. You'll see that our report outlines a number of recommendations how we can effectuate positive change on this issue. While some of those recommendations would require action by the legislature, others are doable as early as tomorrow, and they would make an immediate positive impact on Nebraskans' rights right now. First, we've developed a sample bench card. Bench cards are tools specifically drafted for judges to utilize, and this specific bench card it includes checklists, statutory information, and it's really just a tool that judges can use to ensure statutory compliance for all bail hearings and sentencing hearings that involve any fees or fines. Our judicial branch already provides these type of bench cards. Specifically, bench cards are provided as resources in juvenile cases and other matters. There's no good reason not to also provide judges a tool when they're determining the ability to pay by utilizing a bench card such as the one that we've drafted. We've also developed what are called as pro se legal forms that folks that are without legal representation can use on their own. And we've translated those forms and the directions on how to use those forms into multiple languages, particularly the 5 languages that are most commonly spoken in Nebraska, to really help Nebraskans advocate for the rights that they currently have. We're right now working with officials in Douglas County to make sure that the forms and the instructions are available and accessible in the Douglas County Courthouse. And we're asking judicial branch leaders to advocate for the display and accessibility of these forms, instructions, and the translations across courthouses throughout Nebraska. And finally, it became apparent to us that judicial training should be a priority and is desperately needed in this area. And we believe that it should not just be offered once, but offered on a regular basis. And we've offered our help wherever appropriate to collaborate in the training to ensure that the judges have the resources needed to follow the letter of the law. Now, to be clear, we are going to keep advocating at the Capitol for systemic solutions to eventually end cash bail. The best way to promote fairness and remove wealth from this equation is by updating and overhauling the system as it currently exists. We are clear-eyed that a legislative solution regarding the end of cash bail may take years, but in the meantime, the changes that we've outlined in our report can be implemented quickly to better protect Nebraskans' rights. And as you can tell by Rich and Rose's information, these changes are needed now. We're not going to rest until freedom does not rely on how much money we currently have or have access to. And we are really grateful for you joining us today and helping us highlight this issue. Thank you.
Thank you, Mindy. So floor is open to any journalists on the line here with questions. We can also follow up via email if you want to take some time to go through the report and get back to you. All right. I was always taught to let the silence speak. And I think that's what it was doing there. Please go through the report. Let us know what questions you have. Listen back to their recording or any notes, and our press release will follow this. Get a hold of us if you have questions, but we're very grateful for you hopping on and for your coverage down the road. And don't hesitate to be in touch on these issues. Thanks so much, everyone. Have a good one. Stay dry, stay safe.